Hello, everyone. I am Andrea Chomakos, a partner in the Charlotte office of McGuire Woods, and I am joined today by Addison Fontein, an associate in our Dallas office, practicing in the area of complex commercial litigation. On behalf of McGuire Woods and the Private Wealth Services team, I want to thank everyone for taking some time out of their day to join us in this webinar to discuss alternative notarization methods. A few housekeeping items first. As a courtesy to your fellow attendees, if you would not mind, please muting your line to avoid inadvertent background noise or feedback. Next, you can access and download today's materials by using the widget app, which appears on the bottom of your screen. It is the fourth from the right, just left of the question mark icon. For today's presentation, we are offering various forms of professional education credit, including CFP, CTFA, and CLE credit. You will receive an email from our firm sometime tomorrow afternoon following the presentation where you can access the documentation to confirm and submit your qualification for continuing education credit. Finally, if you do have a question during today's presentation, you can pose that question using the Q&A widget, which is the third widget from the left, appearing at the bottom of your screen. Addison and I will do our best to answer questions posed during the presentation, time permitting, but please know that we will be tracking those questions and will also respond offline after the presentation so that you can be assured that we will do our best to respond to questions posed during this presentation. During today's presentation, Addison and I will be discussing various notarization methods used to attest to the execution of a document. Addison regularly represents financial institutions in her practice, and I am an estate planning attorney with McGuire Woods, working with individuals to execute estate planning documents, often which require witnessing and notarization, as well as also representing financial institutions. So back in March, when our country began facing the effects of the global pandemic of COVID-19, the coronavirus, we received a deluge of calls from clients, individual clients, financial institutions, those participating in various transactions, wondering how they were going to execute documents and have those documents notarized. So a few of us, Addison and I will raise our hands, decided that this was a rather interesting, albeit mundane issue, and we were excited to help jump on the bandwagon to track legislation evolving around the country, as well as executive orders being issued by governors to address the notarization and execution of documents electronically and remotely. And so that is what has led us here today. Through the research that we have done, Addison and myself, we have tracked those statutes. We have analyzed the various different methodologies and are looking forward to presenting to you today that information and hopefully clarifying for many of you what these different alternative methods to traditional notarization actually mean. Many of you have probably heard terms like RON, an acronym for remote online notarization, or remote notarization, or video notarization, and many may think that those are all the same thing. In reality, they're all very different. You may have also heard the term electronic notarization and thought, well, that must be the same thing as RON or remote notarization. And again, that is actually a separate type of notarization. So Addison and I are going to endeavor today to keep you entertained and educated about the various alternative methods of notarization in today's world. So what is notarization and why is it important? So in preparing for today's presentation, I actually did a bit of a deep dive on what notarization is and the history of notarization. And if anyone wants to join me in that history lesson, we can do that offline. But it actually goes back to ancient Rome, where individuals were effectively sanctioned by the emperor to keep track of and document transactions. And it was the records of those individuals who were sanctioned by the emperor that actually controlled whether or not that transaction happened and the details of that transaction. Fast forward a couple thousand years, and in today's world, a notary who is commissioned by a jurisdiction, either a state or a commonwealth, or a municipality within a state or a commonwealth, their commission enables them to attest to the due execution of a document by the person who is signing the document and verifying their identity. When you think of notarization in the traditional sense, you often think of that form that we saw on that cover page, that seal or that embossing, and a wet ink signature by both the principal signing the document as well as the individual notary who is attesting to the execution of that document. And that is still today what we see a majority of the time. But the world is changing, as we all know. And as a result, this ancient form of attestation is also starting to evolve into alternative forms. But the most important thing to recognize about notarization is that it is an independent verification and attestation as to the due execution of a document by the person who is signing the document and verification of their identification, of the principal signing the document.
Hi, everyone. Thanks for joining, and thank you, Andrea, for the introduction and the background on this topic. So I will jump right in. Aside from notarizing documents, there are other ways to execute or sign a document. And one of those ways is electric execution, or putting an electric signature on a document. So the legal basis for electronic execution dates back to 1999, when the Uniform Electronic Transactions Act was introduced at the state level, which authorized states to permit electronic signatures in the same way that, and with the same legal validity as a wet ink signature. So instead of signing a document with a pen, you could do so on a computer by electronic means. Shortly thereafter, in 2000, at the federal level, the Federal Electronic Signatures in Global and National Commerce Act, otherwise known as e-sign, was passed by Congress, and that permitted e-signatures for transactions between two or more parties in all jurisdictions where federal law applies. And UETA and e-sign really provided the stepping stones from a remote online notarization, which is what we're talking about today. So I'm sure almost all of you have e-signed or electronically signed a document before. While we do not condone any particular type of vendor, some popular ones out there are DocuSign or DocVerify, and it's widely used across the world. DocuSign actually advertises that hundreds of millions of individuals have actually signed using their platform. And essentially, to do an electronic signature, you use a digital design platform. And in doing that, you agree to do business electronically, that you intend to sign the document, and that a record will be maintained regarding that electronic signature. And to be valid, that electronic signature on the document has to be capable of retention and reproduction. And e-sign is used for simpler types of documents. And essentially, when you do e-sign, whether you are filling out an agreement, you're pressing a button and attesting that that signature is yours, you intend to sign the document, and then you are agreeing to do business electronically. So while e-signature and the ability to sign something by electronic means has made document signing more efficient, there certainly are exceptions to what can be e-signed and what cannot. We've listed several exceptions to what can be e-signed, and I'll go through some of them, but testamentary documents such as wills and testamentary trusts cannot be signed via e-signature, and Andrea will be addressing in more detail how estate planners have been executing estate planning during the COVID era. Additional documents that cannot be signed via e-sign are matters of family law, transactions under the UCC, negotiable instruments such as checks, court orders or notices. And along those lines, while technically court orders or notices or documents filed in courts cannot be e-signed, different jurisdictions, district courts, federal courts will have local rules that may have an exception to this exception. For instance, an individual signing an affidavit or a declaration may traditionally be required to do that with wet ink, but some federal jurisdictions and federal courts will allow an e-signature to an affidavit. But it's very important to always check the local rules and the federal rules because, for instance, if an individual signs via e-sign an affidavit supporting a dispositive motion or a summary judgment, that could be groundwork for an objection. On the same token, of course, emergency orders that have been introduced by governments and state officials have also allowed exceptions to this list of exceptions to e-signature. But outside of COVID, executing any of these documents via e-signature could lay framework for rendering that document invalid.
Thank you, Addison. So that leads us into the alternative forms of execution and notarization, alternative forms of notarization of documents. So as Addison just mentioned, there are two federal acts that have been passed that permit the electronic execution of a document. And so it begs the question, if a document can be executed electronically, and Addison described what electronic execution actually is, well, if that document's execution also needs to be notarized, how does one notarize an electronic signature or electronic execution of a document? So the first iteration of alternative forms of notarization is electronic notarization or e-notarization. So electronic notarization only applies to the electronic execution of a document. It is a similar format for notarization as Addison described for the execution of that document, in as much as the notary is using that same platform, that same technology platform, and using that same method to adhere their signature, attesting to the execution of that document and adhering their seal to the same. However, electronic notarization, unless it's otherwise described, which we will get into, which is Ron, is not done remotely. It's actually done in person with the person electronically executing the document. So you could envision two people in a room at a computer, both using that same platform to both electronically execute and electronically notarize that document. So that is what e-notarization is. The next form of notarization, we get into an actual remote notarization, or what I will call remote video notarization. And I use that specifically to avoid confusion with the term remote online notarization, because those both use the term remote. So video notarization is actually the traditional notarization of a traditionally executed document but done remotely and via video. And this is the type of notarization that has exploded in popularity and commonality through the COVID pandemic. And the vast majority of the executive orders that have been issued by governors of states, as well as legislation, much of which is temporary, is to authorize remote notarization or video notarization, not RON, remote online notarization. So again, video or remote notarization would involve an individual in a location different from the notary, participating in an audio-video communication platform like something that we're using today, Zoom, which is very popular, or WebEx, or any of those similar types of technologies where both the person executing the document and the notary can see and hear each other at the same time simultaneously. The person who executes the document does so where the notary can visually see that via the audio-video connection. Immediately after executing the document, the individual who executing it transmits it electronically, transmits a copy by scan, PDF, email, or facsimile. The notary receives the full document. The individual who executes the document then mails the original to the notary. Upon receipt of the original by that notary, they compare it to the document that they had received electronically immediately after its execution. And if they're the same, then the notary adheres their signature and seal to that wet ink document. So it's a traditional notarization just done remotely. No part of the execution of that document is electronic. And so it is the traditional form, not the alternative platform of electronic. What I would say on remote and video notarization is a couple of things to be aware of. The first is that all notarization, whether it's traditional, electronic, remote, or RON, still requires identity proofing. Identity proofing is more challenging and more susceptible to fraud when it's done when the folks are remote and or they don't know each other. So identity proofing is can be accomplished if the notary actually has personal knowledge of the individual executing the documents, or a person who is known to the notary attests to the identity of the person signing the document. So it's like a third-party attestation of the identity of the person signing the document. If the notary does not know the person who is signing the document, the person soliciting the notary's assistance, then additional verification of identity needs to take place. And Addison is going to cover that later on in our presentation under her discussion of RON, but just be aware of that. The other thing that I would point out on remote or video notarization, actually two things. One, as Addison mentioned, you always want to check the local or the state rules. Here it would be the state rules. As I mentioned earlier, all notaries are commissioned by a jurisdiction, and they receive their commission through a state agency, typically the Secretary of State, and they are subject to the rules set forth either in the statute or promulgated under the authority granted to that state agency, the Secretary of State's office. And so there is some similarities between the requirements for remote or video notarization among the jurisdictions, but there's still going to be some differences. So make sure that if you're in a location, you know what those rules are and that the notary is adhering to them. The other piece that I want to point out is, to the extent that jurisdictions have authorized video notarization through an executive order as opposed to through statute, There are some people who have raised the question as to the viability of that executive order to actually grant the authority to notaries to conduct their notarizations via that form, remote form, video form. Because again, that executive order is outside the scope of legislation and the statutory construct of commission notaries is such that their authority is granted by the statute and by the agency to which the statute grants authority to govern what they do. So there have been some people who have questioned the effectiveness of those executive orders. So on the next slide, we have listed out the states who have authorized video notarization by statute. There's approximately 17 of those. Some of those are temporary. Some of those statutes are temporary, and some are not. North Carolina's in particular is a temporary statute. There's significantly more states who have authorized video notarization by executive order. Some of those executive orders have expired. They may have subsequently been extended. And there are just 3 states who neither permit video notarization nor RON, and that's California, Oregon, and South Carolina. So the final iteration of all of this is RON, the remote online notarization. And so this, again, as I mentioned before, it can be a little misleading. A lot of people use this term when they're really referring to remote or video notarization. But remote online notarization is the remote electronic notarization of an electronically executed document. And states must authorize RON by statute, must authorize their notaries to attest to and notarize documents via RON. So there's several states who have adopted this, but the most important takeaway from this slide, I think, is just to understand what RON is and what RON is not, and that RON only applies to the electronic execution of documents. So if a document cannot be electronically executed, it cannot be notarized via RON. So on slide number 10, we have listed out the states who, as of today, have enacted RON legislation. Virginia was actually the first state, and it's a commonwealth, to have passed a RON statute. Now there's a total of 22 states plus the District of Columbia, which authorize RON. Some of these states have authorized this just this year. Some have accelerated the effective date of the use of RON in response to COVID. But again, the specific rules and regulations for the notarization of documents using RON are all governed specifically by the statutes and the regulations and rules promulgated in every single state. So it's important that if you are going to utilize this form of notarization in a state, you understand what those rules are.
So now that we know what RON is and what RON isn't, it's time to talk about how RON works and RON in practice. There are 3 fundamental terms associated with RON, and that's technology, retention, and identity proofing. So starting with technology, there has to be a platform that meets certain requirements. One of those requirements is that it's a secure network and has public key infrastructure technology so that the document and the portal cannot be altered or manipulated. The shared platform has to allow for audio and visual communication and for both parties, usually the notary and the signatory, to be able to access and view the document. And just to be clear, FaceTime and Zoom and other conferencing tools are not considered secure for looking at non-public documents, especially per the Gramm-Leach-Bliley Act. So there has to be a third-party shared platform that has all of the requisite criteria for audio, video, security, and then also the whole notary transaction has to be recorded. And after it's recorded, the entire notary transaction has to be retained. So again, since it's a state-by-state statutory scheme for remote online notarization, different states have different timeframes for how long a document has to be retained and stored. Additionally, aside from the states, the governmental sponsored enterprises such as Freddie Mac and Fannie Mae also have different retention spans in place to keep the recording of the notary transaction, and oftentimes that is for the length of the loan, the subject loan at issue. So we talked about the technology that's needed and the retention of the notary transaction, but also prior to even beginning the notary transaction remotely, the notary public has to confirm the identity of the signatory or the principal. And this process is twofold. It's simpler if the person is known to the notary, or there's a credible witness, a person that's known to the notary can verify the signatory's identity. If that's the case, then both the notary and the signatory can proceed with the remote online notary transaction. However, because many remote online platforms are done by third-party vendors, it's often custom that the notary does not personally know the signatory. So if that is the case, then the personal knowledge would not be satisfied. So there's an identity proofing stage, which requires a multi-factor assessment. So in that process, first the signatory would provide a government-issued ID and present it for review by the signatory or by the notary, and that would be a passport or a driver's license or a similar identification card. Then the analysis of that government-issued ID takes place. So the notary or sometimes an additional third-party vendor will review the government-issued ID and make sure that it is not fraudulent, manipulated, or otherwise destroyed or out of date. So they're looking at the font of the ID, they're making sure there's holograms and things like that. So provided that the ID is presented, provided that the ID passes, then there is a knowledge-based assessment stage. And this is something that's different from a lot of other types of notarizations, and each state, again, has different requirements in place for this process. But generally, as an overarching basis for this stage, the knowledge assessment stage, the signatory will be asked a series of questions, and those questions will be about the individual. They will be pulled from public and private databases and are generally questions that only the individual would know. And these are in place to ensure that the individual that's signing the document and having the document notarized is the person that they say they are. So it's to eliminate any potential fraudsters that will try to notarize a document. So as part of this, there are limitations generally both in time and the number of attempts that you can take a knowledge-based assessment to confirm your identity. For instance, Florida has a 2-minute time frame to answer all of the questions, and the individual taking the knowledge-based assessment must get an 80% or higher and can only take the knowledge-based assessment twice. And again, this is to make sure that everything checks out and there's nothing fraudulent as part of the remote online notarization. So I know I've said this 5 times, but it really does bear repeating that every state is entirely different in terms of remote online notarization. So some states, such as Maryland and Utah, will require that both the signatory and the notary, although they are remote, they have to be located in the confines of the state when the RON transaction takes place. So an individual purchasing a real estate and needing a document notarized will have to be, although remotely, in the state of Maryland when that occurs. Other states are a little bit more flexible, especially given the remote stage that many of us are living in. Texas, Minnesota, Nevada, and Wisconsin all allow the notary to be inside the state of where the notary is to be performed, but the signatory can be wherever. The signatory can be on vacation, the signatory can just be out of state, and similarly, New Hampshire is flexible in that way as well, but there's a small caveat in that the remote signatory can be outside the confines of New Hampshire, so long as the notary document relates to property or a matter originating in New Hampshire. So RON is a strategic opportunity in this technology era. It has really proven to be efficient and effective. Forbes recently reported that in-person notary availability is at an all-time low. And this is twofold. I think one, it's because e-signature is now available to execute simpler types of documents. And two, of course, living in a global pandemic, a notary is not going to be as readily available as they once were given social distancing concerns. Notaries now are said to be not accepting signings for 15 days or more, and that has increased over 1,200% compared to just last year in April of 2019, and that's largely, again, said to the pandemic. So RON really has become crucial to continue to complete loans, deals, and real estate transactions. Commentators say that the longer it takes to close the loan, the higher the risk it is of losing the deal. So RON is really transforming the ability to continue to close deals and transact business in the global pandemic that we are living in. Additionally, mortgage software company Ellie Mae said the average closing time is 46 days for purchase transactions and 49 days to refinance. So if a company does not have RON capabilities, there's definitely inherent risks in elongating the life of a loan or a deal. So RON is an evolving technology that is becoming more and more widespread, especially since March of 2020 when the pandemic hit the United States. So there's companies all over that are using RON and facilitating it and really experiencing beneficial results. So just as example, Courtesy Chevrolet in Phoenix, Arizona implemented RON and said it saves time and money, and it also changed the time to complete a sale from 4 to 6 days to half an hour. So you can imagine the time someone would change their mind in the 4 to 6 day range to in a half hour range, you're more likely to finish a sale. Additionally, Realgy Title Group, a subsidiary of Realgy Holdings Group, is said to see a 200% increase in adoption of digital closings using RON. So RON has really transformed in a nice-to-have to a must-have technology, and businesses that have RON or have RON capabilities, whether that's through them or a third party, may have a competitive edge in the marketplace moving forward, especially with the ability to process transactions quicker. So I said earlier that states have specific requirements, but also the governmental sponsored enterprises, the GSEs, Fannie Mae and Freddie Mac, also have additional requirements in place. So, for instance, Fannie Mae makes clear that lenders can sell loans with remotely notarized loan documents in all states, including the District of Columbia, except for California, Maine, Mississippi, Rhode Island, and West Virginia. Also, a Texas loan document in connection with equity encumbering a homestead property in Texas cannot have a notarized document associated with that. So it's really important to not only look at the state requirements, but also definitely look and check out the GSE requirements and see all of the different requirements in place just to ensure that there's no document that can be rendered invalid down the road. So because RON is an evolving technology, there's definitely going to be potential issues that arise, and there's issues that we haven't even seen yet. So considerations to take into account are, while a state or other entity may allow for RON and everyone may agree to RON, there will be third parties that aren't going to be willing to accept a document through RON. Also, not all documents can be executed through RON. A document first has to be eligible to be electronically executed in order to be notarized through RON. And again, if your document that you need notarized can't be executed through electronic execution, then perhaps you want to consider video notarization, which we've talked about a little bit before, and we'll get into in more detail in a few slides. Again, be aware of the state-specific requirements. Notaries also have to have a separate RON commission to perform notarial acts. So an individual that has a traditional notary commission will also have to get a RON commission. And there's also time and cost efficiencies to consider. If a notary is not using a third party to assist with the knowledge-based assessment in remote online notarization, then the notary is going to have to spend some time to come up with questions for identity proofing, and that might delay the RON transaction for just a bit. And also, because there's technology involved, because there's a knowledge-based authentication process involved, the fee associated with RON is higher than the fee associated with traditional notarization or just electronically signing a document, of course. Additionally, insurance policies often have a litany of exclusions and exceptions, and oftentimes we're told to read the policy, read every line, and I think more specifically, many errors and omissions policies actually exclude claims, coverage, or payment for subpoenas and disciplinary proceedings where the notarized certification or signature is performed without the physical presence of the person whose signature is notarized. So that would exclude remote online notarization. So it's very important to take any type of coverage that you're seeking for an insurance product into account. So given the fact that there's a state-by-state variance across the country in implementing RON, using RON, and the requirements therein, many ask, will there be a nationwide solution, or is there a nationwide solution? And right now, there is not a nationwide solution. At the beginning of COVID in March 2020, a bipartisan bill was introduced called Secure. And what that would do is it would allow for remote online notarization in every state, and it would also establish minimum federal standards for RON. So that would create nationwide certainty, consistency across the states. But the caveat is that while Secure would really set the floor for RON, states would still be allowed to set the ceiling. States would still allowed to have different requirements and different rules that would need to be followed. So while this would allow for RON nationwide, it wouldn't necessarily have a nationwide solution for all of the different variances from state to state. Again, the Secure bill has not been passed yet, but we've added a link to track it to see if there's any developments, and we'll certainly be monitoring that closely and are looking forward to the results.
Thanks, Addison. So as Addison mentioned earlier, RON is not available for electronically executed documents, and one of the primary exceptions to the two acts, federal acts that permit the electronic execution of documents, that's the UETA and e-sign, they accept estate planning documents from being electronically executed. So unless a state has passed an electronic wills statute, all estate planning documents must be signed by a traditional wet signature, which means that they have to be notarized by traditional wet signature. As I talked about earlier, remote or video notarization is an option for states that do permit it, if you can follow those protocols. And estate planning documents may be able to be signed by remote or video notarization. But we're going to take some time during this last section of today's presentation to focus specifically on the conundrum that we estate planners find ourselves in when we have documents that need to be signed by our clients by a wet traditional signature, and they need to be witnessed and or notarized as well. And sometimes those clients are not in a position where they can be around persons for their own personal health and safety and protection. And so remote or video notarization does present a viable option, as well as just looking a little bit outside of the box from how we estate planners have traditionally executed documents in our practices. So first, there are 4 jurisdictions that have passed statutes authorizing the electronic execution of wills. Those 4 jurisdictions are Arizona, Nevada, DC, and Florida. Both the District of Columbia's statute and Florida's statutes are effective as of 2020. Florida's statute became effective January 1st of this year. DC's became effective, I believe, in either March or April of this year. So they're both relatively new. This is a very new area of the law for us estate planners. As you can see, there's very few states that currently authorize it. It is a potentially viable option, but recognize that what the actual statutes say. They are electronic wills. They're providing for the electronic execution of wills, not the electronic execution of other estate planning documents that we estate planners commonly use in our portfolio of documents, whether it's a trust instrument, a power of attorney, a healthcare directive. And we'll talk a little bit about those. But unless the document can be electronically executed, it cannot be electronically notarized. So what other options are out there if you have a client who needs to execute an estate planning document, a will, and they are not in Arizona, DC, Florida, or Nevada, or you're not comfortable, or that client's not comfortable using electronic means for execution? So there are a number of states that do permit the execution and probate of what is referred to as a holographic will. So for the lawyers on the phone, you may have to hearken back to your bar review days or your second year estates course, wills and estates course, to remember what a holographic will is. But a holographic will is a document a writing that is entirely in the testator's handwriting and signed and dated by the testator. It does not require witnessing, and it does not require notarization. And so, again, there's a handful of states that do permit holographic wills. North Carolina, which is where I practice, is one of those states. I actually have a petition pending as of right now before the Mecklenburg County Probate Court, which is our Clerk of Superior Court, to probate a holographic will. So they do come up. I've also assisted some clients who have not been comfortable for whatever reason executing a traditional typewritten document. I've assisted them in handwriting a document. So it is possible to do if you have a client in one of these jurisdictions. The next is there are some states who do not require a typewritten will to be notarized, or that notarization is only required to meet the self-proving attestation, which permits a more streamlined probate of that document. But in each of these jurisdictions that don't require notarization to a typewritten will, the document does require witnessing. And so again, that's putting somebody in the same area with other persons who typically by statute cannot be related by blood or marriage to the person signing the document in order to be a qualified witness. So it just depends on circumstances whether or not you would be able to meet, have a client who could have an in-person signing of a will and witnessing of a will. I will tell you that during this era, I have met with clients and witnessed and notarized documents using the CDC protocols, keeping a distance, wearing a mask. I've met with folks on their back porches. We try to pick a nice weather day as best as we can and to do that, so you get a little creative. But here's a listing of states that don't require that the wills actually be notarized to be eligible for probate. But where you get into some more difficulties is outside of the will context, specifically durable powers of attorney and healthcare documents. And as an estate planner for over 20 years, I can tell you that in my opinion, these are the documents that are the most important for an individual to have, especially an elderly person or somebody who is facing an illness, is to make sure that there is someone who can handle their financial affairs for them during their life as authorized pursuant to a durable financial power of attorney, or to make healthcare decisions for them if they're unable to do so. I am not aware of any statutory exceptions during COVID to the notarization requirements for powers of attorney. I'm also not aware of any state that does not require a power of attorney to be notarized. They're all required to be notarized. Some states also require witnesses to a power of attorney. Healthcare documents typically statutorily require just witnesses, not notaries. I, in my practice, and I know many others in their practices, will also have healthcare directives notarized as well as witnessed. But some states have passed executive orders, governors have issued executive orders, or states have issued temporary statutes relaxing the witnessing rules for healthcare directives in particular. North Carolina is one of those states. I believe Michigan, where I'm also licensed to practice, is another one of those states. And what I have then done for clients in those circumstances is I have prepared those healthcare documents, removed the witnessing provisions, and included specifically a statement on the document that indicates that the document is being executed without witnesses as a result of concerns related to COVID-19 and pursuant to, and then I'll either list out the statute or act or the executive order. I think it's important to let a third party who may view that document to understand why it looks different than what they're traditionally used to seeing, and give them the authority to go to verify that that document has been properly executed, even though it is not witnessed or notarized. So I think that jurisdictions are doing the best that they can to ease those restrictions. But also remember that you do have the ability to execute documents via remote means. To the extent that, I know we've talked a lot about remote notarization, but to the extent that a document requires a witnessing and that can't be done in person, again, look at the relevant authority in that state, whether it's the legislation, the act that's been passed or enacted, or the executive order to see if it permits remote witnessing. Some do and some do not. So there is some, some digging that you may have to do, and we're here as a resource. Addison and I have been tracking these executive orders and statutes throughout the spring. Things sort of eased up a bit during the summer months, but I suspect that we'll continue to see actions in these areas generally throughout the fall and winter as the pandemic continues. We hope that this information today was helpful to all of you. We hope that all of you are staying safe and healthy and mentally well during these very difficult times. That is the phrase of the year, I think, these very difficult times. But Addison and myself and all of us at McGuire Woods are here to be helpful to you and a resource to you and to your clients. And we look forward to connecting with you and assisting you on these and other matters. Thank you.